Hi everyone, this is Steve Maggi from SMA Law Firm. One of our chief concentrations here is consular law practice. We've helped people process their visas at US embassies and consulates around the world for the last 16 years. And so there's something new called the national interest exception, which applies to individuals who are either stuck outside the US and are living in countries where they cannot directly come to the US because they're barred from traveling from those countries, or there are specific visa categories that are not being issued until the end of the year unless they meet the exception. And one of those is the H-1B visa. The H-1B visa is used by US employers to employ foreign nationals with university degrees. A lot of you who are employing H-1B individuals may have those people in the United States under optional practical training, and our advice is to keep them in the US until they can change their status to H-1B on October 1st. But for those of you who are stuck outside the US and who may have already had H-1B status, or for some reason traveled before the completion of your H-1B application process in the US, once you have an approved petition, the only way that you can re-enter the US now is under the national interest exception. So I'm going to go through that with all of you. It's a lot more complex than it actually sounds, and so it's important that you work with a professional who is specialized in consular law in order to be successful. One of the exceptions is for travel by applicants who are resuming ongoing employment in the US with the same position, the same employer, and in this case, the H-1B visa classification, because USCIS says that if you are forcing employers to replace those employees in this specific situation, it could cause them undue financial hardship. So if you have an H-1B visa approved previously and you were going to apply for a new visa, perhaps your H-1B status is no longer valid, but you have a petition approved by USCIS, you will qualify for the exception and can get an appointment, an emergency appointment at a US embassy or consulate where you reside in order to get your H-1B visa stamp. Let's say you don't fall into that category. What are the requirements to qualify under H-1B? Well, there are 5, and you have to qualify under at least 2 of these categories. The first one is that the petitioning employer has a continued need for the services that they sponsored you for. So this is implied, but it's also strictly, and it's enumerated here specifically. So if they sponsored you for a petition and that was approved and they still have the need for your services, then you meet that first requirement, which leaves just one more. The second one is that the proposed duties will provide significant and unique contributions to the employer, meeting a critical infrastructure need. There is a specific listing of all the different infrastructure projects and verticals that this might apply to. You need to make sure that it applies to one of those. And then on top of that, you need to hold one of these specific 2 kinds of positions to qualify under the second prong, which is senior level placement, or with job duties reflecting performance of functions that are unique and vital to the management and success of the business enterprise, or the applicant's proposed job duties and specialized qualifications indicate that they will provide a significant and unique contribution to the petitioning company. So here you have to make an argument that is above and beyond by showing the impact, the economic impact that you will have on the employer, why they need you specifically. And the best argument to make here is to extrapolate that and to say, if this person is allowed to get the exception and their visa, that will lead to not only more revenue creation, but the creation of more jobs based on that person's presence. The third prong here is that the wage rate that's going to be paid by the company is 15% above what was in the labor conditions application. So it's 15% above the prevailing wage. If the company shows such a strong need for that employee that they're willing to pay more than 15% above the prevailing wage, then they meet that prong, and that could be your second prong right there. The fourth one is that the applicant's education, training, and experience demonstrate unusual expertise in that specialty occupation. So they give an example of an applicant with a doctorate or professional degree or many years of relevant work experience. So this is essentially advantageous to employers sponsoring H-1B candidates who are not at skill level 1, but that are skill level 3 or 4, perhaps based on their advanced degrees or their advanced level of experience. The last one is a financial hardship argument, which is that if you deny the exception, that this will cause financial hardship to the US employer. Those are the 5 requirements. They're very nuanced, and it's very important that when you apply for this exception, that you do so comprehensively and exhaustively by presenting it all in one document with an employer letter. And of course, it's good to work with an attorney specialized in consular law who is also very comfortable working with H-1B requirements, because the marriage of those two specializations means that they are equipped to successfully present your case. If you do get your case denied, you can apply for the visa after the end of 2020. But if you want your candidates here in the United States working for you on the proposed start date of October 1st, or if it's an extension of their H-1B they previously had and you want them here as soon as possible, we strongly suggest that you apply for the national interest exception. If you have any questions, you can contact us anytime. And thanks so much for watching this video. Have a great day.